What? You have a temporary green card through marriage to a US citizen and you're facing deportation because you filed an I-751 to remove the condition on your green card? That is bizarre. As bizarre as this may be, it is true. You can be in a real marriage, living with your spouse, building your life together, and still end up in removal proceedings. I've seen it happen, and in most cases, the person never thought their green card was at risk. Now, if you stay with me, I'm going to explain how applying for citizenship can actually trigger a denial of your I-751, why USCIS is taking a harder look at conditional residence right now, and what you must do to protect yourself. Here's what we are going to cover today. Why conditional green card approvals without interviews are creating problems later. How a pending I-751 and an N-400 together can collide in one interview. And also, drumroll, what happens legally when an I-751 is denied. Also, the type of evidence USCIS is now expecting to see. And what to do if your marriage is falling apart before filing the I-751. Now, let me tell you the main story here. Over the past few years, many marriage-based green card cases were approved with minimal scrutiny. A large number of couples never had to have an interview. You submitted some paperwork to USCIS, and you were given a 2-year conditional residence. For some couples, that was perfectly fine. The marriage was real and the documentation was solid. But for others, the approval came more easily than expected. That created a false sense of security. Here's what the problem starts now. A conditional green card is not a permanent status. It's only for 2 years. It's temporary. After 2 years, you must file Form I-751 to remove the condition, and the burden is on you to prove that the marriage has been genuine from the beginning and continues to be genuine. I recently reviewed a case that illustrates this risk. The couple had a joint bank statement, an insurance policy, a lease, a handful of photographs. That was enough to secure the initial green card, the first green card. 2 years later, when it came time to removing the condition, they submitted essentially the same thing. But at this point, USCIS expected them to have more. 2 years of marriage should generate a paper trail. Joint taxes, renewed leases or a mortgage, utility bills, travel records, birth certificates of children, affidavits, shared financial obligations, a growing record of shared life. Instead, it looked like everything was frozen in time. While the I-751 was still pending, the applicants filed for naturalization at the same time. This is allowed under many cases after 3 years of permanent residency through marriage. But when you apply for citizenship with a pending I-751, USCIS will often combine the interviews. In the interview, the officer does not test just civics, but they go into your marriage as well. The I-751 becomes the question. And once the I-751 is denied, your conditional residence status is terminated. Legally, you're no longer a permanent resident in the United States. That is exactly what happened in this case. The individuals walked in focusing on the citizenship test. My client walked out facing deportation proceedings. The issue was that the marriage was fake. The issue was that the evidence that they gave was sparse. They had pretty much the same things that they had 2 years before. This is the key lesson. Do not treat the I-751 as a routine formality. It is a real test of your marriage. Start preparing the day you receive your conditional green card. Keep records, save joint documents, file taxes together, maintain an organized level of documentation. Now, let me address another mistake I see. If your marriage has broken down, do not stay in a toxic or dead relationship just to file the I-751 jointly. Do not ask your spouse to play along. If you already are separated, you're separated. You need to do a different thing. There are waiver options for individuals who entered the marriage in good faith but later were divorced. You can still remove the condition without filing jointly in the right circumstances. But it must be done strategically and honestly. You need a lawyer to help you. The bottom line is this: conditional residence is not automatic citizenship, and it's not an automatic forever green card. You're exposing yourself to scrutiny of the government if you go in without proper documentation. Get proper guidance first. A strong, well-documented case prepared in advance can mean the difference between approval and removal proceedings. Now, you may ask yourself, why did we walk in with that one client where they didn't have enough documentation? They didn't have enough documentation. That's the bottom line. You can't manufacture things. If you don't have them, you don't have them. Through our guidance, we tried to put together as much as we could we did something even more crucial for them. They were going to walk in with some documentation that was made up. And this is the last warning I want to give you in this video before I say goodbye. And that's, make sure your documentation is correct, legal, and not made up stuff. Because if you're found out that in order to remove the condition, you're offering them documentation or evidence or testimony that is questionable, you're now not only just facing deportation because of having run out of this visa, but also because you're misrepresenting a material fact, which in itself is quite problematic. Anyway, I hope this video has helped you. Give us a call. We've been practicing immigration law for almost 30 years, and we've had many tough cases where we've been successful. Nice chatting with you. Thank you.